So let's say you're at dinner and you have a few drinks and you're driving home and all of a sudden you see the blue lights in your rearview mirror. What do you do?
That's a great question. And I'll tell you, through most of my career, I've done a lot of DUI work. And honestly, it's tough to even know exactly what to do depending on where you've been and how much you've had to drink, if anything at all. But once those blue lights come on, boy, you need to be prepared. And I'll tell you what I mean. You've had a few drinks, you're driving home, you're not impaired. There's nothing illegal about that activity. It is not against the law to drink and drive. It's against the law to drink to the point of excess where your normal faculties are impaired and then to drive an automobile. So of course the blues come on. Do you gun it? Heck no. You stop, you pull over, you're respectful to the deputy. But do you have to cooperate with the entire investigation? Would you have to do field sobriety exercises? Would you have to take a breath test? That's going to be a subjective decision depending on how things are going. For instance, the first thing they normally do, they'll ask for your driver's license, registration, and proof of insurance. Hopefully, you're going to have that ready and be able to present them. If he asks you where you've been or where you're going, it's not a big deal to tell them that if you know, but please be cognizant that you may be being recorded. You might be being recorded by even a microphone on his uniform, his or her uniform. So frankly, if it's even questionable as to whether you felt that you were safe to drive home, less is more.
Is it important to act quickly when you get arrested for a DUI?
The first thing I'd recommend is get a lawyer. Get a lawyer quickly. It's important to act quick in a DUI. In a DUI case in the state of Florida, there's both a civil administrative suspension upon your driver's license and perhaps, if you're convicted, a criminal suspension of your driver's license. On the civil aspect of it, you only have 10 days from the date of your arrest to make application for formal review hearing. A formal review hearing is different than being in a court of law. The standard is different. The purpose of review is different. And the whole question is whether you've breached your contract with the state of Florida, the contract by which you say, please give me a driver's license, and in exchange they say, well, please submit to a chemical test of your blood or breath if suspected by law enforcement to be impaired. It's a contract from day one when you get your driver's license, and if you break that contract, they have a right to suspend, they being the state of Florida. The formal review hearing has a consequence to your license because before you can qualify for a hardship license, that's assuming you lost at the formal review hearing, if you took the breath test, you'd have 30 days of hard time. Hard time's not chain gang, I-95, making driver's license plates or anything. Hard time means you don't have a business purpose only license. You have no license whatsoever. Being here a local attorney in Brevard County for 21 years, I'll tell you that in this county, it's a very long county, 76, 78 miles, it's a long county. It's tough to work in this county if you don't have a driver's license. So it's important to try to do everything you can to get at least a hardship license, a business purpose or education purpose license back as quickly as possible. So stage one is a formal review hearing. Some lawyers ignore that. I just don't understand that. I can't fathom why you'd ignore that, because on its worst day, it's an opportunity to get your license back, and it's an opportunity to get a free peek at the cards as to what the case is going to be about for your client. I think formal review hearings are critical to any successful, zealous defense of a DUI.
So tell me what happens at a formal review hearing.
The formal review hearing is an administrative hearing conducted by the Department of Highway Safety and Motor Vehicles. There are two types of hearings. One's an informal and the other's a formal review. The informal is pretty much just reviewing the records to see if they've dotted their I's and crossed their T's. I strongly recommend that we always set formal review hearings because then we have the ability to subpoena the arresting officer. At those hearings, we're not dealing with the same elements that we'd have in an actual court of law. In the formal review hearing, we're dealing with whether there was probable cause, whether the driver was placed under lawful arrest, whether they were warned of the consequences of a refusal if they refused the breath test, and whether in fact they refused the breath test. In the alternate cases, we're dealing with, of course, probable cause, lawful arrest, and whether they took the breath test but exceeded 0.08. So at that hearing, it's important to note, and this is one reason why they're not particularly popular with a lot of defense lawyers, we're dealing with a civil burden of proof. Burdens of proof are strange. In criminal law, they have to prove a case beyond and to the exclusion of any reasonable doubt. It's a very high burden. It's very difficult. It should be very difficult anyway for the state to prove that. But in a civil hearing, we're dealing with a civil burden called a preponderance of the evidence, which is simply a very formal, fancy way of saying more likely than not. Where the question in one of those administrative hearings is it more likely than not that the officer that made the stop and the arrest had probable cause? Is it more likely than not it placed the driver under lawful arrest? And is it more likely than not that the driver blew over a 0.08 or was properly warned after they refused the breath test?
So you are pulled over and the officer asks you to take a breathalyzer test. Do you take the breath test then?
That's a great question. And it's a tough question. I'll give you some examples as to why. In the state of Florida, if a person took the breath test and they blew triple zeros up to 0.04, it's a very low reading, there's actually a presumption in favor of non-impairment. So you help your case if you took the breath test if you've only had one or a slight drink. Let's say that they blew from 04 to 08. There's neither a presumption in favor of impairment nor a presumption against, so it's kind of neutral evidence. If you ask me, and it depends on the size person, how well their body accepts alcohol, whether they have food in their stomach, how long they've been drinking, with all those factors combined, it's really subjective. I would suggest if you had a few over a short period of time, then you're likely better off not taking the breath test, because simply they're not going to unarrest you. One thing that people usually don't catch is the fact that you've already been placed under arrest for DUI before they even ask you to take the breath test. They're not allowed to ask you to take a breath test when it's simply the investigation of DUI. So they're not going to unarrest you. If it was a level playing field, I'd suggest let them take a breath test, and if they were 0.04, unhandcuff them and send them on their way. But it doesn't work that way. So since the rules are that they're not going to unarrest you, with all due respect, if it's even a close call, I don't see the point in cooperating with their investigation further.